The third time sitting MP, member of the CWC and chairman of the Parliamentary Standing Committee, jurist and national spokesperson of the Congress, Dr. Abhishek Manu Singhvi, joining us on the broadcast. Dr. Singhvi, thank you so much for joining us on the show. Cutting straight to the topic, to the brass tacks of it, the government argues that this entire move is a reformative move and it is aimed at shedding the colonial baggage. Do you agree with that argument, sir?
Unfortunately, and I say with great respect, there cannot be a greater misrepresentation than this. This is completely wrong. And let me give you on that just a few figures first. There are about 1,059 sections in these mega acts. For 150 years, we've had IPC, and then 75 years CRPC and Evidence Act, etc., etc. Actually, in a real sense, they've made changes in the IPC, which is now called BNS, to only 2.24% of the provisions. They claim they've made 34% changes. And I'll tell you why there's a hiatus between 2.24 and 34. It's because they've simply picked up 30, 40 provisions of the old one and consolidated them into one chapter or into one heading. Chapter 2, Chapter 17. It's nothing but a transfer and a consolidation. So you count every comma full stop as a change, then it comes to 34. The real change is at 2.24%. That's your structural change for you. The second is the BNSS, the erstwhile CRPC. They claim 22% in the same cosmetic manner, completely cosmetic. Actual changes is 1.68%.
All right.
And last is the Evidence Act, called BS now. Claimed is 13.77%. Actually, is only one change. 0.17%. Now, therefore, it is not wrong to say khoda pahad nikla chuha, or shayad chuha bhi nahi nikla. Before I come to the 3 or 4 important facets, and we'll go along as we go along, one is a set of things which you could do. It's a missed opportunity you did not do. Nobody is saying you don't require changes. We're all welcoming changes. Laws require updating. So first is, what are those which, had you done, would have been welcome, but you did not do. You missed an opportunity. Second is the ones you did. Many of them, how retrograde and blunderous they are. And the third aspect is that really it is your fetish for name changing. I don't want to sound political, but let me tell you that you somehow love to leave your identity, your imprint, your chhap, as they say in Hindi. So you have gone on a name changing spree. In the political sphere, from 1975 to 2013, you have 33 examples where you simply change the name of schemes. This is a very major change, example of merely a change of the name of a statute.
Well, sir, I take that point, but give me substantial reasons. You argued that at length, but I'd like to know more. That why this is a cosmetic exercise. The government argues that, look, for example, the offence of sedition, a commitment that they gave to the Supreme Court of India that we do away with it. They have come through on it. And sedition as an offence, as it earlier existed on the statute book, does not exist. And in fact, these are progressive changes that have been made. One of the examples that I'm quoting out of the many key changes that have been made, sir.
I mean, you have to start consulting Alice in Wonderland dictionary. I call it retrograde and the government calls it progressive. One of us has to be wrong. Now you judge for yourself. There are 4 examples of retrograde I have chosen. There are many, many, many more. But of the 4, let me take your example first, sedition.
Sure.
I mean, I'm amazed that somebody in the government is calling it progressive. I said, not entirely in jest, that certainly the government can't be accused of sedition itself, but it can be accused of betrayal. The government makes a statement, first of all, in the courts on 11th of May 22, the court gives a stay of the sedition offence. They reiterate it on 30th of October 2022 and record the statement of no less than the Attorney General that we are seriously reconsidering. Seriously. The result of that so-called serious reconsideration is that on 24th May 23, which is 1 year later, the Law Commission reincarnates sedition. And immediately on the next day, if you read the newspapers, the government distances itself from its Law Commission, saying, "Hum to sarkar hai, ye to Law Commission hai, Vidhi Ayog hai." As if they are fooling people who believe that the Law Commission is functioning in a silo or a ivory tower itself. Now, what is reincarnated today is worse than the previous provision. There is no difference in substance. What about your assurance that you'll do away with it altogether? And the old one had a punishment, Anusha, of life plus 3 years. This one has life plus 7 years. And this is your definition of much better provision, progressive or more tailored. Last point.
Sure.
You are sitting in Gujarat, you say anything the government doesn't like, the Assam police comes and arrests you for sedition. We've done those cases. I'm actually a lawyer in many of those cases. You are sitting as a journalist in Uttar Pradesh. How many of your colleagues have been arrested for sedition? Now, today, by simply changing cosmetically something or the other, there is no change, it is worse. Now, let me give you 2 or 3 other quick examples of retrograde. You have created a new offense of sexual intercourse by deceitful means. This is a new provision, clause 69. The law standing committee report itself very strangely puts it under the head, appreciated provisions leading to love jihad. So this kind of provision is a satisfaction of your preconceived agenda about love jihad. Why? Because you have given a humongously disproportionate penalty of 10 years for this. 10 years.
Okay.
You already have an offense that you are deemed to commit rape if you have sex on false pretenses.
Yes.
Now you have made it into a separate offense for love jihad. Clearly you know how it is used in actual on the ground. Innocents are harassed. Today it carries a 10-year.
Sure. Sir, there's this one issue that I want to talk to you about, and there has been much chatter about it. You would know that better as a litigating lawyer, that how does this reorganization or renumbering of various provisions, consolidation of various provisions of the Indian Penal Code actually affect the existing jurisprudence, and a rich one which has been set by the High Court and the Supreme Court in this country?
You have again brought me back to the most vital practical concern. And you could not be more right. This is the consequence when you act without knowledge. These unintended consequences are the most dangerous.
Sure.
I'm not saying anybody's intention, including this government's, cannot be to increase our arrears of 5 crores to 7 crores. No man on earth would want that. I'm not accusing the government of that. But as they say, the path to hell is paved with good intentions. Howsoever good your intention, if your unintended consequence of your actions is 5 to 7 crores, the best example is this: you have tinkered with whatever 500 odd provisions. Actual change of a substantive nature or of a real nature is 2.24% or 1.68 or 1, but nominally, facially, the changes are 34% to BNS IPC, 22% to BNSS CRPC, and 13% to BS Evidence Act. Now that many changes means that you are a judge. You got 100 Supreme Court judgments on section XYZ.
Okay.
You know it inside out. When an accused or prosecution comes, you know how to slot him. You are right, you are wrong, as per judgment so and so. Now today the first thing the accused will get up and say, my lords, there is new law now. This is changed. A comma is changed. Now you decide it all over again. That Supreme Court judgment which you had doesn't bind you. Now the funny part is that the judge will ultimately reiterate the Supreme Court judgment. But that will take time. The certainty of established jurisprudence goes.
Okay.
The certainty of having a law which covers it goes.
But sir, to conclude, and this is my last question to you, coming back to the original question that I asked you, shedding the colonial baggage, it's a loaded term, and in many ways to break it down into different portions is very difficult. Have we actually shed the colonial baggage? And if we have, in what way and in what form?
Answer to the second question is tragically no. Absolutely no. I've just given you the reasons and the examples. How can you shed a colonial baggage, so-called, with these percentages of changes? But the first question is more important. Look, Anusha, these are not matters to be decided by ideology or preconceived, premeditated object. You must change your law if it is bad. You must not change it because it was made by Aurangzeb, who is considered a cruel ruler. You must not change it. Suppose he made a very good law. Should you change it only because it's his name? Therefore, the British made good laws also. But equally, the British made bad laws. You are changing them not because they are British made. You are changing them because they are bad laws. Now, that exercise, if you're done with that mindset, you ended up changing and doing a lot of good.
Okay.
Who is saying that the IPC is perfect? But the examples I've given now, take for example, what you did not do. Police reforms. One of the most important things you could have done. Now, this is what you could have done, did not do. The other example was what you did was wrong.
Okay.
Police reforms makes a simple Chinese is unfashionable, Indian wall between prosecution and investigation. You know, your average investigator, IO as they call them, gets up in the morning, the poor fellow goes in the field, collects some evidence, obviously gets attached to it because he's the one who's collected it, comes back to the office and sits with somebody in his own department, his superior, etc., to decide whether it's prosecutable evidence. His own evidence collected is prosecutable or not. Does odd chores for his superiors, wastes his time, and attends 2-3 hours of court also.
Okay.
Imagine this man's plight. A, he's overworked. B, there is a lack of objectivity, impartiality, and transparency. I collect the evidence and I also decide prosecution. Now, you have been told by 40 years that separate these two. Prakash Singh's judgment in Supreme Court, several law commission reports. You could have done that by this amendment. Now, did you do that? Why? You talk of colonialism, you talking of British. You do not actually wanted to reform.
Okay.
That's the problem. Take, for example, making it more reform and less punitive. Why didn't you increase? So therefore, it's clear that I want changes. But what changes is the question. Why don't you increase the list of compoundable offences? Compoundable offences are those which you can settle.
Yeah.
Now, there are innumerable petty offences which can be always added to the compoundable list, like impersonating a public servant.
Sure.
These are matters where if you want to settle, you can't settle. And you will clog your courts and clog your jails. Third, punishment alignment. These are changes they should have done. Today, there are a number of provisions where offence is more serious, the punishment is less.
Yeah.
And the next provision is, and the next offence is less serious, but the punishment is more.
Okay.
Take, for example, bribery during elections. It is only 1 year. Inciting a riot is only 6 months. Align the punishment proportional to the issue. You have not done any of this.
Dr. Singhvi, thank you so much for joining us on the broadcast. It's always a pleasure to speak with you.